Hello, my name is Cesar Pereira. I'm a fellow in the immediate past chairman of the CIArb Brazil branch. And it's my pleasure to welcome you to one more episode of CIArb Brazil Moment. This is a partnership of CIArb with Arbitration Channel. And I thank especially F. Bonas Advogados, our sponsor for this program. As you all know, on March the 8th this year, a few weeks ago, we had an incredible program at CIArb Brazil, which was a Moot demonstration round between the winner of the Rio de Janeiro Pre-Moot, Universidade Federal do Rio de Janeiro, and a team instructed exclusively by ChatGPT. This was an incredible success. We have had hundreds of views of the recording of that session. There were over 200 people participating live at that session, and we were all very much surprised at how well, in a way, ChatGPT did at that demonstration round. And so we take advantage now of this partnership with Arbitration Channel to have here with us the people that were behind that initiative. We have here André Guscov Cardoso, who is an arbitration a technology law specialist, and was the first person I approached when we thought of having that demonstration round, and to whom I first asked if that was remotely doable, and he was able to prove us that yes, it was perfectly doable. And when we also have here Douglas Amorim, who was, so to speak, the tech coach of ChatGPT, and Fernanda Romero, who was the legal coach of ChatGPT. André Guscov Cardoso is a lawyer and has a master's in administrative law. But for maybe at least the past 10 years, has been focusing his practice and his academic studies in tech law. And he is nowadays one of the most renowned Brazilian specialists in this field. Douglas Amorim is a data scientist. He has he graduated in computer science from the University of São Paulo, and has an MBA. Has an MBA in data science, is a master's candidate in artificial intelligence, all that at the University of São Paulo. He has been a part of the AI in data team at Microsoft, has worked in commercial banks, in projects such as the very well-known PIX, which everybody in Brazil knows what it is, and also open banking at the Central Bank of Brazil. He now is part of the fintech Quanto, in which he is responsible for data products strategy and development. And he is also a professor of machine learning and big data at the graduate courses of FIAP in São Paulo. And Fernanda Romero is a lawyer. She has been involved as a participant in the Moot competition in Vienna. She participated in the 2018 edition. Since she graduated from the School of Law of Fundação Getúlio Vargas in São Paulo in 2021. She has been working as a corporate lawyer, and has now since then been focusing her studies also in economics. She's an undergraduate student of economics at at the School of Economics of Fundação Getúlio Vargas in São Paulo. And so this team here has been involved since the beginning in various aspects of that initiative. And as you know, that the initiative of putting ChatGPT against a human team at Moot was a way to test how that would work in practice, because it's very difficult to emulate a real arbitration hearing, and with all its characteristics, but that is in a way what the Moot competition does. It structures an arbitration hearing in a way that you can easily identify the performance of the various participants, and it's structured for that. And so I thought it was a very clever initiative to transport that, which is already in a way a simplification of an arbitration hearing that's designed to assess the performance of human advocates, to use ChatGPT in that same setting, and be able to, in a way, compare how ChatGPT would do in this environment. So that's basically what that initiative was about. And I would like to start by asking André about this initiative and his impressions about how it went about. This demonstration of ChatGPT using the Moot case in a dispute against the human team from the Federal University of Rio de Janeiro, which was the winner of the Rio Moot, was absolutely a great success, and it generated a wide repercussion. I know you have been interviewed and you have written about that. And so how do you see that experience? How do you assess the outcome of this initiative?
First of all, thank you for reuniting the team. It's good to be here and to talk about the backstage, the behind the curtains work on this experiment. And as you mentioned, Cesar, it was a great experience, a great success. I think that more than 1,300 views in the recording of the video. So for those that could not, that haven't not seen yet the recording and seeing the experiment, this is a good thing to do after knowing how it was done, how the sausage was done before. So it's a good, it was a great experience for me and personally. In objective terms, it was a great experiment. Where, for what we know, this was the first experiment using ChatGPT for this purpose, for this kind of dispute, or moot dispute in arbitration. And as you mentioned, Cesar, this was a kind of experimentation of a new technology of using AI tools, a specific kind of AI tool that's ChatGPT, that's based on large language models, to dispute with a human team. this kind of comparison, this kind of disputes are very well known when dealing with artificial intelligence. We know, and we already know of disputes around involving chess and the game Go, and now we have this kind of disputes involving arbitration and arbitration dispute Moot. And we could see in the experiment that the use of AI tools had a result that was acceptable, that was a good result, comparable maybe to a regular human team, to the performance of a regular human team. And this was interesting because we checked that all the hype about ChatGPT using in other areas was useful also for the use on the legal profession and specifically on arbitration. And the other side of the experiment showed us the current limitations of the technology, problems as hallucination, as excess of sincerity by the ChatGPT program, by the ChatGPT system, were also present in the experiment. For all these characteristics, it's a very, very interesting experiment because it poses a lot of things, a lot of material to think about and to examine how can we use this kind of technology with the legal services, or with the performance of legal services, with the arbitration disputes in general.
Thank you, André. And it's interesting to notice that, and we can talk about this later, that this was done with the general purpose ChatGPT that's available for everybody, either free or at $20 per month. And so one can only imagine what will happen when we have purpose-driven, dedicated systems like that trained in legal matters. But Douglas, turning to you now, from a technical point of view, can you explain to us the logic behind ChatGPT? What technical difficulties did you encounter using ChatGPT? Andrea mentioned some limitations. If you could maybe address them. In short, was it easy to get to the excellent performance of ChatGPT at the March 8th event?
Of course. First of all, hello, Cesar, Fernanda, Andrea, and everyone who is watching this stream. It's my pleasure to be here discussing such interesting topic with all of you. And let's go. ChatGPT, it's a large language model that makes use of transformers. Transformers is a technique created by Google scientists in 2017, and it's based on a mathematical concept called attention, which analyzes the relationship between words in a text. The focus in model training is to analyze a text based on how the words appear, the order between them, and how they relate to each other. In other words, how the occurrence of one word influences the other words that appear afterwards, whether the next word is the next one or that they appears 10 positions ahead. Based on this training, ChatGPT goal is to generate text that are syntactically correct and make sense for human reading, generating word by word. So it's in the way that ChatGPT works. The technical challenge that we faced were related to the input of text into the model. At that time, when we did the competition, ChatGPT only accepted plain text as input and had a limit of 4,096 characters. So this is a very restricted size of input. And a total of 3,000 words as a context. As ChatGPT is already trained as a general purpose network, our biggest challenge to obtain a results we presented in the competition was to have human curation to be able to cut out sections of the documents that were good enough to provide context to ChatGPT, but at the same time stayed within the space limit for processing in the GPT 3.5. Today, this task could be a bit easier since ChatGPT 4 can handle 24 words, which is 8 times more than ChatGPT 3.5.
Oh, that's interesting to know. So, in this, let's say, 3 weeks period, or let's since you obviously you started working on this earlier, and so let's say in 2 months, we increased in this general purpose ChatGPT system. We increased the this capacity 8 times in terms of providing additional context, right? So that would certainly have made your life a lot easier, as we will hear from Fernanda in a moment. Fernanda, you were Moody, right? So you participated as an oralist at the Vismoot in 2018, and you lived all the preparation work for the competitions, for the pre-moot, for the actual competition in Vienna. Many people, after our experiment earlier this month, are asking themselves how you all did to teach ChatGPT the Vismut problem, and to give this context. How did it work in practice? How did ChatGPT became apt to even answer questions from the tribunal, as anybody can see? Any one of the 1,300 people that have already viewed the recording have already seen, and anybody else can see by looking at the recording. So how did ChatGPT became capable of answering questions in real time and even preparing rebuttals and rebuttals at the round? So please, if you could explain it to us, it would be great.
Hi, thank you for having me. So our strategy to train ChatGPT was honestly one of trial and error. So we started with the easiest possible approach, and where we adapted as we faced difficulties. So to outline a little the steps that we took, first we checked if ChatGPT already had access to the Vismut case in its database. As it did not, we then tried to submit a link to the case so that ChatGPT would read the case for itself, but it was not able to browse the internet. So then, as it cannot read the case for itself, we tried, as Douglas mentioned, to convert the case into a text format and copy and paste it into ChatGPT. However, we had this new problem, which was that it only allowed a certain amount of characters. So then we divided the case into multiple messages and copied and pasted them into ChatGPT. But now the issue was that there were a lot of messages and ChatGPT had a limited storage capacity. So that meant that after a few messages, it no longer remembered the information that we had sent in the beginning. So finally, our approach that worked was to create 4 different sections, one for each part of the case, and select pieces of the case that were relevant for each of the arguments. So in this way, we were left with 4 different chats, one for each section of the case, And then we asked ChatGPT to prepare the pleadings using the facts, the laws applicable to the case, and precedents from courts and tribunals, which it already had in its database. We didn't provide any context on laws or precedents. It already had this information within it. And as regards the questions and rebuttal, since it already had all this information in each of the 4 different chats, and the amount of data was small, it was able to access this previous information and answer questions and prepare rebuttals. The only important aspect here is that we had to structure the question well. So, for example, if we wanted a rebuttal on a certain point, it was important to indicate which point we were going to attack and how long the answer should be.
That's very interesting in terms of, and I will come back to you later on that point, in terms of the skills that lawyers must have now to, in a way, drive ChatGPT, right? Because it's a tool, and like any tool, like a car, like a plane, like anything, it has to be driven properly. Otherwise, it has to be used properly. Otherwise, it will not give you the results that it can give. And so I think that this illustrates very well that we humans will always have a role in terms of curation, as Douglas mentioned, in terms of prompting, as this is also described. So this is very interesting. Andre, going back to you, from a more, let's say, from a legal point of view, and from a broader perspective of the use of artificial intelligence and machine learning in arbitration, what precautions and concerns do you think we should bear in mind?
In fact, there are 2 possible approaches for this question, Cesar. A specific approach deals with the possible problems and limitations concerning the use of artificial intelligence tools as ChatGPT in the legal profession, in the performance of legal services, and in arbitration too. And these, as we mentioned before, and Douglas explained, and Fernanda also mentioned, we were able to detect some limitations to the technology, some specific limitations that the tendency of hallucination that I have mentioned before, and the problem of the limitation of the prompts is also a problem. But the idea is that the broad use of of artificial intelligence tools in arbitration or in the legal profession or in dispute resolution in general could lead to some questions, mostly legal questions concerning fairness and equality in the arbitration process, of the due process in general. We can imagine discussions about equal treatment of the parties, transparency in the use of AI. Till today, all these new technologies were used by the firms, by the attorneys, and by the parties in order to enhance their capacity to process documents and process information. But now with ChatGPT, we are before a new technology, a specific technology that deals with language, and the use of language is essentially in the core of the legal profession. So when we use this kind of tools that deals with language, we can enhance the legal profession, but we can also pose some threats to the due process of law. we can treat parts unequally. One part used, for example, using artificial intelligence to defend itself, and with an attorney, with a lawyer, and another party that only use a lawyer without using these new technologies could be could be jeopardized. Its defense, his or her defense could be jeopardized. So the idea of preservation of the process could be an idea that could raise from this kind of discussion. The idea also of the protection of personal data, privacy, confidentiality of the arbitral process is also a concern when dealing with this kind of tool that is provided by a third party, by a company that's not controlled by the parties, nor by the arbitral tribunal. So this kind of concern related to the process is also a concern. But there's another possible view on this question, that is concerns about the legal profession itself. The Wall Street Journal some days ago published a piece comparing, and I can. The piece is the jobs most exposed to ChatGPT. It's based on a paper that was published by researchers of University of Pennsylvania and OpenAI that detected, or this paper tried to detect what were the most exposed professions and jobs by using ChatGPT, and they reached some conclusions. In general, the idea is that the profession is related to the use of language, or to the use of math and to do calculations is more affected by this kind of new technology. So probably legal professions will be affected by this new technology, but probably will not be replaced by these new tools, this new kind of AI tools. And the human, we can say that the human touch in this kind of profession is still necessary, at least for what we could see in this seminal experiment.
Thank you, Andre. Yeah, I saw an interesting comment about in the same line that you mentioned on the Financial Times, saying that that lawyers would probably be very directly affected. And it's interesting that all of us here either deal with language or math, right? And so it will be interesting to think how affected we will all be. But I saw something else that was also interesting about the need or not to disclose that we are using artificial intelligence such as ChatGPT in preparing an award as an arbitrator, or in preparing a submission as an advocate. And the discussion was, well, maybe not, because this is a tool, and we do not have to disclose if we did research on Google, if we did research on a legal database, or where we got the information, right? We get the information, we are responsible for that information, and it must be submitted in a format that's legally acceptable. And provided we do all that, maybe we don't have to disclose that information was created by ChatGPT. The discussion there was not about the legal aspects of this whole thing. It was more whether, let's say, if you're writing an article, whether you're supposed to say at the end, this article was written by ChatGPT, because it was written by ChatGPT, but it's written on your prompts to ChatGPT. And so ChatGPT, or any other tool like that, is just an instrument for you to exercise your creativity. So, but I think that is very much related with what I would like to ask Douglas. Now, Douglas, Andrea mentioned a few times the idea of hallucinations, and we all know you described the way ChatGPT works. We all know that it's not really committed to truthfulness. It's committed to plausibility, to the idea that a certain sentence makes sense, not necessarily that it's true. And I know that in your practice rounds for the exercise in March, you even had some surprises, like ChatGPT made up some cases, and so not only it went to its database to find, as Fernanda mentioned, to find cases that were there that were not given by you as context, but it also made up some other cases, right? And later it admitted, because when you ask it, it's sincere. But anyway, this idea of hallucination, should it be avoided? Should it be corrected? Or can we use it in a productive way?
Okay, great. First, let's define what hallucination is. Hallucination AI can be defined in a simplified way as the fact that AI generates a text with conviction and syntactically correct, but that does not correspond to something feasible or even seen in its training data sets. Therefore, it can invent information to meet the interests of questions. The discussion of whether we should avoid it or not, in my opinion, depends on the balance between control and innovation that the task demands. Why? I believe that hallucination is the way in which artificial intelligence can innovate, can be creative, and so therefore we should analyze the application and understand how much the task benefits from a creative approach with more margin for this hallucination, such as writing a fiction story or something like this, or if it's a task that demands more control and compliance, such as analyzing a legal document or some related activity. So I think it's a balance demand between creativity and compliance and control. It's not only one correct answer about hallucination.
Yeah, that's very interesting. I think as you were saying, ChatGPT with this idea of hallucination can have a very important role in the, let's say, brainstorming stages of some discussion, right? And so it's probably hallucination, as you said, is something that has to be understood, but it can probably be used productively if you know it's there, if you know that things that you may receive from ChatGPT may be not exactly compliant with with structures, but can give you a different angle for something that you hadn't thought before, and that can be developed. And so, well, I think that's a very good way to see hallucination as something useful, not necessarily a problem. And Fernanda, I would like to close getting back to you. After this experience with ChatGPT, and after your own experience as a young corporate lawyer, having lived the practical activities of a law firm, and having seen what young lawyers do, how do you see the practical professional use of tools like ChatGPT in professional life? what kind of skills do you think lawyers, especially young lawyers, must have from now on, now that we are dealing with this type of tool?
I believe in general that there's a lot of room for the use of more advanced technologies in the practice of law. Despite the limitations that we mentioned, ChatGPT did a very good job at quickly structuring an argument, finding legal grounds, finding precedents. So I believe that the competitiveness of the legal market will require eventually the adoption of more efficient methods, and these technologies are key. One of the biggest practical obstacles, in my view, is that these tools, at least in the beginning, will require a lot of patience from young lawyers. First, because in general, there is a learning process to each of these tools, be it ChatGPT or any other tool. Such as in the case of ChatGPT, it was essential to know how to provide information, how to structure a question. So these skills that are specific to each tool, I think, will require patience. And the second reason is that these tools have a potential lack of accuracy. So that means that it is essential for you to carefully review the results. So I think this will also be important. But yeah, I think that as these tools improve, there's a lot of room for their adoption. It is important that we as young lawyers become familiar with them.
I think this is a very good message to end this talk. The idea that we need to understand these tools, that they can be useful. They can be. They are not. They are not going to necessarily replace human work, but will certainly change human work, because some mechanical things that we do that can be done more efficiently will be done more efficiently, but there will be a lot of room, a lot of spaces that still require the human ability to ask the right questions, to structure the way these tools are prompted, and to make sure that the results are adjusted to the requirements of a fair process. And those are all concerns that we must have, and that are very well illustrated by the experiment that you all put together. So I would like to thank you, André, Douglas, and Fernanda, for your time, for sharing this information, and for sharing your insights with us. And I would like to end this episode of CIArb Brazil Moment by again thanking Arbitration Channel for this partnership, and thanking F. Bonassa Advogados for its support to this program. See you next time on April the 12th with the next episode of CIArb Brazil Moment. Goodbye.